What legal jargon is in student-athlete agent agreements? Have you ever wondered what legal terms are hidden in student-athlete agent agreements? These documents are more than just signatures. They define the relationship between student-athletes and their agents. Understanding this legal jargon is essential for any student-athlete looking to navigate their sports and academic careers effectively. First, let's talk about the agency contract. This is the formal agreement where the student-athlete gives the agent permission to negotiate contracts on their behalf. It can be either oral or written, but it must follow state laws and the rules of the educational institution. Next, the agreement outlines the services the agent will provide. This can include contract negotiation, marketing, and managing endorsements. Knowing what services are included helps student-athletes understand what they are paying for. The duration of the contract is another important aspect. This section specifies how long the agreement will last, including the start and end dates. It is crucial for student-athletes to know when their obligations begin and end. Expenses and reimbursements are also detailed in the agreement. This part explains any costs the student-athlete must cover, like travel or administrative fees. Being aware of these expenses can help avoid surprises later on. One of the most critical components is the conspicuous warning notices. These are bold statements that alert the student-athlete to significant consequences. For instance, signing the agreement may lead to a loss of eligibility to compete in college sports. Additionally, the student-athlete must notify their athletic director within a specific time frame, often 72 hours after signing. There is also a notice to the educational institution. The agent is required to inform the student-athlete's school about the agreement within a set period. This ensures that the institution is aware of the agent's involvement. Another key term is the voidability clause. If the contract does not meet legal requirements, the student-athlete can void it without any penalties. This clause protects the athlete from being bound to an unfair agreement. Agents often need to be registered with state authorities under laws like the Uniform Athlete Agent Act. If they fail to register, the agreement may be voided or lead to penalties. Restrictions on representation are also outlined in these agreements. For example, National Collegiate Athletic Association rules prevent agents from representing student-athletes for certain purposes while they maintain their collegiate eligibility. Finally, disclosure and record-keeping are required. Agents must provide a copy of the signed agreement to the student-athlete and keep records as mandated by law. Understanding these terms is vital for student-athletes. They must recognize the implications of signing an agent agreement on their eligibility and academic standing. Reviewing these contracts carefully, ideally with legal counsel, can help them navigate the challenges of balancing sports and academics. This knowledge empowers student-athletes to make informed decisions about their futures.